This week, President Joe Biden announced proposals to reform the Supreme Court, including a new constitutional amendment that no former president's immune from crimes committed in office, 18-year Supreme Court term limits, and a binding code of conduct for Supreme Court justices. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. In this episode of We the People, we'll discuss President Biden's proposed court reforms and explore the relationship between politics and the judiciary from the founding until today. Joining me to discuss this urgently important question are two leading scholars of the Constitution and the Supreme Court. Anthony Michael Kreis is an assistant professor of law at Georgia State University College of Law, where he teaches constitutional law and employment discrimination. His new book, which is just out, is Rot and Revival, The History of Constitutional Law in Political Development. Anthony, it's great to welcome you to We the People, and congrats on the book.
Thank you so much, and it's really a pleasure to be here.
And Keith Whittington is David Boies Professor at Yale Law School. He's the author of many important books, including Political Foundations of Judicial Supremacy, Repugnant Laws, Judicial Review of Acts of Congress from the Founding to the Present, and most recently, You Can't Teach That, The Battle Over University Classrooms. Keith, it is always wonderful to welcome you to We the People.
Thank you very much.
Let's start with President Biden's three proposals. Keith, you wrote a piece recently laying out some possible objections to each of them. Tell us what you think of the three proposals to create a constitutional immunity amendment, 18-year term limits, and a binding code of conduct.
Well, unfortunately, we don't really have any details yet as to what the proposals look like. And I think the details are going to be really important in this case, is to know what kind of complications the administration would actually face in trying to push this forward, and what kind of concerns it might raise. The constitutional amendment, of course, is really designed to reverse the outcome of Trump versus the United States, which said that the president has, or a former president, has immunity from prosecution arising out of acts he engaged in while conducting his office of the presidency. A constitutional amendment obviously is the best approach to trying to address that, although Senator Schumer has just announced he's going to try a statutory approach to mitigate the effects of that ruling as well. I think, though, the details will matter in this context as well. There are real implications if you simply say presidents have no immunity from criminal liability for anything they do. It does potentially open some can of worms about can Congress then go in and criminalize all kinds of presidential acts they don't like in order to tie the hands of presidents in some significant way. And if you simply pass a straightforward constitutional amendment, it's going to do the obvious things you would like to do, but it may do a lot more than that. And I think Congress has to think really carefully about what the text of such an amendment would look like, and how do they avoid creating problems even as they're trying to solve some problems. The other two proposals are more focused on the court. And one is suggesting establishing term limits for the justices. Of course, the Constitution specifies justices serve, as do all federal judges, during good behavior, which has been understood as life tenure. There have been proposals floating around for a while to impose some kind of system of fixed terms for particularly Supreme Court justices. President Biden endorsed what is the more popular timeframe for that, which is an 18-year term. What he did not say, and I think is really crucial, is whether he proposes to do this through constitutional amendment or proposes to do it through simple statute. There are some folks who think it can be done through statute. I think that's constitutionally very challenging. But politically, legislatively, obviously, it's the easier path than trying to go through a constitutional amendment process. If you go down the statutory path, I think it creates some real challenges of its own that may be worth exploring. And finally, the third component of the Biden proposal, as he characterizes it, an enforceable code of conduct on the justices. He specified a few things he would like to see in such a code of conduct, including restrictions on what gifts they can take, for example, what kinds of political activities they can engage in. I think the real challenge here is thinking about what enforceability means in the context of Supreme Court justices. There's a bit of a question about to what degree Congress, by statute, can simply impose restrictions on the justices and what they do. But I think there are even bigger challenges in thinking about what kind of enforcement mechanisms might you create if you think judges have potentially violated those. The obvious option is the impeachment power, but of course Congress already has that, and this code of conduct would add nothing to what Congress already possesses through the impeachment power. And so then the question is there more that you want to do besides the impeachment power? And if so, does Congress actually have the constitutional authority to do that?
Thank you very much for that thoughtful outline of the proposals and for laying out some of the possible objections to statutory solutions. Anthony, what are your thoughts on the proposals? Maybe some more details on some of the statutory objections, including redefining life tenure by statute, as well as the separation of powers questions in Congress imposing an ethics code.
Yeah. So I think one of the first things I want to lay out here is obviously I don't think anybody thinks that President Biden is going to be able to push any kind of package, whether it be a statutory package of reforms or a proposed constitutional amendment through Congress, just because of the political dynamics as they are. And so I do think it's really important to highlight this is in many respects, but just position taking, maybe perhaps in advance of the election to kind of bring it to the fore of conversation. It also, I think, perhaps has the effect of moving the Overton window a bit, because for a very long time, right, there are all these different questions of, well, what do you do about court reform if you're a liberal and you want to do something about the Supreme Court? And a number of people said, well, the court should be expanded. Just pack the court with more justices and justify it by kind of judicial some kind of judicial economy based need. That, I think the window has moved over a little bit because of that. So I think that's one interesting dynamic that I'm watching, in addition to the conversations about the substance of the proposals. In terms of the presidential immunity question, I think Professor Whittington is really quite right about this, that the details really matter here. So one of the things, for example, that people have talked about as well, the president should never have immunity from anything. Well, I think even liberals should take a step back and consider, well, what does that actually mean? So if Joe Biden decides on his way out in January of 2025 that he thinks that his son, Hunter Biden, deserves a pardon, would it be proper for that exercise of that pardon, right? And we're talking about a pardon done because he thinks it's the right thing, right? It's not been sold, it's not been improperly, done for some other reasons, but just because he thinks it's the right thing to do. Could a subsequent Republican administration suddenly charge him for obstruction of justice for simply exercising the pardon power, right? I think most liberals would say, of course not. But that would be the consequence of having a rule that says a president never gets immunity for anything. And so this really does need to be fine-tuned and thought about in a way that I think respects some of the inherent authority and the prerogatives that the president has, without kind of creating this large swath of immunity that the court has given the presidency now. So that's one thing I think is important. In terms of the term limits, to me, I think there's a really good question about whether this can be done by statute versus whether it has to be done by constitutional amendment. I mean, fundamentally, the courts are creatures, and federal judicial seats are creatures of Congress. Congress makes them. Congress can abolish them. To what extent they can do that, we had some interesting controversies in the early 1800s about that, and we may have those again. But it's there are two, I think, really important varying viewpoints here. The one being that good behavior is a term for life, and so that the judges have this kind of property right, this vested interest in their seats, and the reason for that is for judicial independence and to ensure that judges can't be subject to the whims of the political moment. And so that's something that I think most of us were taught as in elementary school, and most of us assumed to be true. And that might say something about the history and tradition of judicial tenure in the United States that is really important, right? That we've always kind of assumed that good behavior meant life terms for judges and justices on the Supreme Court. On the other hand, I think I think there's some really interesting mixed history here. So, there was, of course, a number of references in the Constitutional Convention to judges and justices as being individuals who would serve for life, right? And this idea that good behavior meant life. There's also some really interesting English history here, where traditionally judges served at the pleasure of the king. And there was a slow evolution from the mid 13th century to including this idea of good behavior, right? A kind of for cause regime. And then there was another regime where people could receive certain kinds of royal based appointments for life. And so there is some evidence there too that members of the founding era, right, or founding fathers would have known that you could have designated something for life versus good behavior, and maybe that means something different. So in other words, maybe the terms of the office can be set by Congress, but the terms in which the office is held is a different standard. So I think there's really an interesting debate to be had about that history, because there's a lot of, I think, maybe perhaps more unknowns about that history than really hard, fast knowns. And so I think we're going to have a robust debate about that. And then in terms of judicial ethics, certainly this is capitalizing on all the news stories that have been broken over the past few years about gifts that have been received, particularly by Justice Thomas and the like. And certainly the Biden administration is attempting to capitalize on those news stories and further weaken the court in the eyes of the American public. And so that is I think they're trying to build on that public outrage that has been expressed over the past few months. But again, as Professor Whittington astutely noted, the enforcement mechanism is everything. Disclosure is great, and it's important to have disclosure for all sorts of reasons. But how do you enforce that? How do you enforce a willful neglect in terms of disclosure information and things like that? Those details are really important, and I think something that maybe judges would be skeptical of if they were asked to assess the constitutionality of that and whether or not Congress is infringing on their rights as Article 3 judges. So a lot of interesting issues, a lot of interesting politics around these issues, and a lot of complicated questions about the constitutionality of it. But again, to reinforce what I think Professor Whittington said, and I agree with, is that the devil is really in the details for all of these.
Thank you very much for that and for bringing history to bear in helping us thinking about these questions. Well, I was eager to have both of you on because you've written such important books about the relationship between law and politics throughout American constitutional history. And Keith, in your really illuminating book, The Political Foundations of Judicial Supremacy, you argue that two competing notions of the role of the courts have battled throughout American history. One is departmentalism associated with justices, that presidents can interpret the Constitution differently than the courts. The other, judicial supremacy, the court has the last word. And you say that at transformative moments in American politics, in particular Jefferson, Lincoln, FDR, and Reagan, the departmentalist view has been used to transform the courts, and eventually the courts have consolidated the new understanding. Tell us about the thesis. It's complicated but really important, and what light it casts on our current vexations.
Yeah, I think certainly in the current era, we tend to think of the court not only having a final word on what the Constitution means, but really being the primary player in telling us what the Constitution means. There's a lot of deference to judicial interpretations by other branches and by the people at large. There's a real inclination for elected leaders at this point to say, well, constitutional issues are really questions for the court, and we can't weigh in on that, or we can't resolve those. And so we'll just have to wait and see what the court tells us. And that's not always the way we've approached either the Constitution or the courts and their authority to speak to constitutional issues. There's a longstanding respect for the idea that courts ought to be able to resolve the cases that come for them, and other political branches should not interfere with the resolution of those individual cases. But it's been periodically much more contested as to the degree to which the court should really have the final word on what we take to be the meaning of the Constitution, and what kind of independent responsibility do the other branches have, both the executive branch and the legislative branch, to be thinking about what the Constitution means themselves, to try try to adhere to their understandings of the Constitution as they engage in their own practices and actions, and to what degree sometimes they may come to different conclusions about what the Constitution means than what the court might think it means. And I think that there's a certain periodicity to how the president in particular and the court have related on these issues over time, that presidents through much of American history are often very content to have the courts take the lead in thinking about constitutional issues. Frequently, those constitutional issues are controversial. They frequently are unpopular with the general public, or they may divide the president's own political coalition. And presidents, in many of those circumstances, are happy not to have to take responsibility for articulating what the Constitution means, or even adhering necessarily to what the Constitution means, but to sort of say, well, the courts have resolved this and my hands are now tied, and you can blame it on those unelected judges as to what they've done. But that's not always been true. There have been occasions, I think, when presidents both feel that the direction in which the court has gone and how it thinks about the Constitution is radically at odds with the president's own political agenda and policy agenda more generally, their larger constitutional and ideological vision about what the future of the country might look like. And there are greater political incentives for presidents then to take command of the Constitution and control over it and really own a set of constitutional interpretations and say, no, this is what I think the Constitution means. I'm going to campaign on that. I'm going to win elections on that. My party's going to win elections on that. And others who disagree with those interpretations should take a back seat to the interpretations I have to offer. And that may include the court itself, ultimately. What the form of the pushback looks like can vary. But as was suggested a while ago, that part of what we can see with these kinds of measures, even that President Biden has now suggested, is they are a bit in keeping with proposals that politicians have made in the past, which often don't come to fruition, but they are a shot across the bow at the court. And the justices pay attention to that kind of political pressure. And the justices are often very reluctant to actually pick fights with the elected branches if it feels like the elected branches are serious about their commitments and actually willing to have a real fight. The justices will frequently back down. And sometimes jostling over these kinds of court reforms is one of the ways in which political branches signal to the courts, no, we actually care about this one, and we're not happy with the direction you're going. Maybe you ought to take a back seat for a little while on where we're headed.
Thank you very much for that, and look forward to delving into the details of your really, really important and illuminating book. Anthony, you have an important new book out as well, Rot and Revival. And in it, you argue that the courts broadly, over time, have reflected political consensuses. And you apply a model, the American political development model, in particular that of time, which suggests, you argue, that over time and in central moments in American history, including Jackson, Lincoln, FDR, and Reagan, presidents have made realigning political proposals, and the courts have reflected those proposals through transformative appointments. Tell us more about your important argument and its implications for our current debates.
So maybe I'll start off with the implications for some of the current debates, and I'll use what I thought was a really interesting but wrong New York Times op-ed that appeared a few months ago, where a number of liberal law professors, of which I count myself among, were bemoaning how terrible it is to teach constitutional law in an era in which all of these precedents in which they valued, and I share in their values as well, but that they're going away, and part of the reason I responded in the Times to that piece is because I think so much of the way in which we teach constitutional law is wrong in the legal academy, right? We don't really appreciate history. I teach constitutional law about the history of doctrine through time. And if you approach it that way, you understand that what we're experiencing now in terms of political debate and people believing, I think, for myself at least, rightly, that we're in a moment of constitutional crisis, is that we're always in a kind of a moment of crisis, that there's always controversy, that there's always this jostling between the Supreme Court, the political branches, and members of the public, and these kind of bigger ideas that are percolating through social movements and other kinds of kind of grassroots political coalitions. And so in the book, I try to harness this idea, right, obviously in a much more expansive way, but I try to reject in a detailed way the notion of the Constitution is somehow divorced from contemporary political realities. And so I attempt to show how American constitutional law reflects the ideological commitments of dominant political coalitions, the consequences of major public policy choices, and then the influences of intervening social movements all at the same time. And so I draw on a very rich historical record and political science methods in this American political development model. And I try to demonstrate that courts have always been, and they never will be, institutions that lie outside of the currents of national politics. So one of the key themes of the book, and something that I think is particularly rich given we're in the middle of a very heated and contested election cycle for the presidency, is that we hear time and time and time again, this is the most important election of our lifetimes. I think Donald Trump said it last week. I think Kamala Harris said it when she was in Atlanta this week. We hear it all the time. Of course, it's not true. What is true is, it's undoubtedly true that every election, every presidential election in particular, disrupts the status quo more or less in some way. But not every election disrupts the status quo in the same exact way or to the same exact degree. And some elections have they kind of manifest this sharp break from longstanding prevailing norms. And they kind of create this new coalition with a mandate to not just govern, but to govern in a way that entirely refashions the baseline norms and notions of legitimacy, where there's a call for rearranging institutional relationships, and dominant ideological principles shape the polity for years. They become the new baseline norm. And so these kind of grand ideas become like institutions unto themselves. And the elections of 1800, 1823, 1860, 1932, 1980, all represent these kind of order-shattering events in which the American public ushered in this new decades-long coalitional ideological regime that would kind of set the conditions for governing, right? Can set the tenets of what Main Street governance would look like. And a lot of times these moments are responses to the pre-existing political order and their seeming inability to meet the exigencies of the moment and difficult periods in American history, right? They can no longer provide policy prescriptions for the challenges the nation faces. And so the public perceives that inability to respond appropriately as kind of a national betrayal. And these moments between, right, a new coalition coming into power and that same coalition ending is what we would call political time. And so the book attempts to look at that kind of recurrent pattern of political time and see how constitutional law develops in a way parallel to those different political times. So I look at these, again, the period between Reconstruction and disjunction of coalitions, and kind of match up how coalitions shift and change over time, and how Supreme Court doctrine fairly quickly, in a lagging fashion, but fairly quickly responds and looks like those changing conditions on the ground. And so, it's not as if American constitutional law just looks like public opinion polls. Like, you can't hold up a mirror to the court's doctrine and say, oh, wow, that's an exact reflection of how the public thinks at any one moment. It's not quite that simple. But I think if you look at this kind of interactive effect of coalitional regime principles and institutional relationships and the time-sensitive ordering of public policy, you can see how new politics are produced and how dominant regimes innovate and evolve around those new politics. And you can also track that in constitutional law. And so, federal courts, the Supreme Court is often a byproduct of the regimes that make them. And part of that is just the selection effect of how we create, new judgeships and how we select appointees for those judges, right? The president nominates, the Senate confirms. And part of it is, some kind of external forces too. And so, I think we have just been mistaken for a long time in believing that the courts and the Constitution always have some objective meaning. And I think, there are better arguments for constitutional interpretation than not. And we can always have that debate, and people will have that debate. But at the end of the day, I think, right, politics drives so much of constitutional law, and people just generally don't realize it because they're part of a society that's that has a majoritarian view, and the Supreme Court historically has also reflected that majoritarian view. And so because of that lack of friction between the majority of the court and the ideology that the court espouses through constitutional law and the kind of dominant views of the public and of political parties, people just don't see a friction because there generally isn't any. It's where the friction arises between the court being in one kind of space and political time and perhaps the public being in another, where you create this clash. And that's something that we saw in the 1930s. It's something that we saw in the 1860s. It's something that we saw in the early 1800s in the wake of the election of 1800. It's probably something that we're seeing now. Now, to what extent, or how deep that those divisions are and what the consequences are, we probably won't know for many decades to come, right? Talk to me in 15 years and I'll let you know what 2024 meant or what 2020 meant. Those are going to be open-ended questions for a long time. But, to go back to my opening here, right, which is, people will say we are in this kind of moment of constitutional crisis. We're in this moment of disruption and agitation in the constitutional order. And I would say, yes, I agree with you on substance, perhaps, but this is not new. It is not out of the ordinary. This is very much an American story, and it's something that we've seen time and again throughout American history.
Thank you very much for clearly and powerfully putting the thesis of your book on the table, and both identifying the relationship between politics and law is more complicated than just public opinion polls, but reflecting new political coalition, and also focusing on these moments of friction that arise when the court is in one space in political time and the public in another. Keith, would love any thoughts you have on Anthony's thesis, if you'd like to share them, and then really help us dig in on the current moment. If 1980 was a realigning moment, is the current court simply expressing the consolidation of the Reagan constitutional vision? And are the Biden proposals an effort to repudiate the Reagan constitutional understanding and create a new one? Or are they something else? And what does that say about the likelihood of success in court curbing measures?
Well, Anthony's thesis is certainly music to my ears. And in general, I work in a very similar tradition of how to think about the relationship between constitutional law and politics, and how to think about American constitutional political history over time. And I think he's absolutely on the right track and trying to think about those connections as they're expressed. I think the one thing I would add is just a layer on top of the points that he would emphasize in that discussion is the extent to which I think there are also very long waves of development that occur within constitutional law that are not necessarily closely tied to these sort of, for example, electoral changes and the like. And we see the court can be somewhat independently developing a set of commitments from what is really even being seriously talked about or thought about in the other branches of government, partially reflecting the kinds of sensibilities that lawyers and judges are bringing to the table and the kinds of cases they're confronting. Those can develop off-cycle in some sense. They're not responding to exactly the same kinds of political crises. So if you think about the New Deal, for example, it puts directly on the table a whole set of issues that pose really significant challenges, not only to how politics works and how the economy works, but also how the Constitution was understood as working as it was leading into the 1930s. And there was a real effort in both the judicial branches and the political branches is to try to rethink how is our government going to operate going forward, and what kind of constitutional system do we have given these reforms and re-understandings that we're engaged with, for example. And so there's sort of this very close connection between sort of the particular issues of the Depression and the pressures it's putting on politics and the kinds of reforms that occur in response to that. By contrast, we see these other kinds of long trajectories of a kind of due process revolution that occurs on the court over time, a free speech revolution that occurs on the court over time, which are developing somewhat more slowly. They're not responding to a specific set of events necessarily, but are reflecting sort of a rising sensibility among lawyers and judges about the need for certain kinds of procedural protections, for example, concerns about minorities in society and how best to protect them, the importance of individual rights and how to rethink them in part in a post-New Deal world to some degree. And those get developed a little differently and for slightly different kinds of reasons. But there's also, again, a push and pull between what's happening in politics and society more broadly, and then how judges are responding as they're thinking through the specifics of their situation. I think to tie it back, though, to something more like the current period, as you raised in your question, I do think that we are, to some degree, of course, still seeing some of the long tail of the Reagan movement and the kind of conservative legal movement that was arising in and around the Reagan administration, and that is shaping the conservative justices who are on the courts now and how they're thinking about constitutional law in general. I don't think there's a one-to-one reflection of everything that you would see in the 1980s. If you go back and revisit the 1980s and the constitutional debates there's a surprising number of things that were very much on the sort of conservative legal agenda that have sort of fallen away, and other things that have come to a great deal of prominence. For example, as you once wrote at one point about the Constitution in exile, in which there were a set of sort of conservative lawyers and activists sort of out in the wilderness trying to influence what direction the court would go. Some of those ideas have penetrated into the federal court system and have played themselves out to some degree. And some of the visions of the Constitution and ideas about constitutional law that were prominent on the left are now a bit more in exile than they once were. We may see the emergence of a new Constitution in exile from the left, in which they're going to be waiting to bring to the court a set of ideas that they're busily developing out in the political wilderness, so to speak. But part of what we're seeing now, I think, is quite distinctive, unusual about our current situation is how long have dealt with a situation of stalemate. And so, as Anthony suggested, right, it's hard to tell if you're in that moment of maybe this is finally going to be the change, right? That we see a new regime struggling to be born. But we've been thinking that for quite some time now, and yet there's been a real challenge in getting a coalition actually put together politically that was very stable and fixed. It's been hard to identify what kinds of political and constitutional values are going to be regnant and widely endorsed and broadly shared and are going to help guide politics moving forward. And there's a lot of competing ideas and potential movements that are sort of on the table and have been for a while, and none of them have been terribly successful so far. And so we've seen this really striking pattern of a new party captures the White House, for example, and they immediately find themselves losing parts of Congress in the process. No one seems to be able to consolidate a firm grip on the federal government in ways that have been historically very unusual. This is not how the system normally works. And as a consequence, we see the White House and the Congress and the courts more out of step with one another than is traditionally true. Through much of American history. And so I think we've seen more tensions developing between those institutions than we've seen before. We've seen less consolidation on the same set of ideas than we've seen in some past moments in time. And I think a lot of us who take this sort of historical and political approach to thinking about how these events play themselves out have really been sort of waiting for that successful political movement to consolidate some power, consolidate some real public support around a vision that will not only guide the elected branches of the government, but may also then pull in the courts and have real influence about what constitutional vision is coming forward. I guess I not yet very persuaded that this election is going to provide that. But you never can tell. It might. And I think we are going to have two pretty different options on the table in front of us being offered by the Democrats and Republicans. And maybe this will really be the election cycle when voters really do decide we don't like one, we really like the other, and we're actually going to give enough of a majority to one of those parties, and it will be a stable enough majority that they can actually run with their governing vision and play out those principles and really build a government and a political culture around that vision.
That's such an important point that this may be a time when the White House, Congress, and the courts are more out of step with each other than at other times in American history, and identifying when a realigning election occurs is never easy to predict. Anthony, what to make of how unusual it is that the three branches are out of step, as you describe it in your book, in the previous realigning moments, including Jefferson, Lincoln, FDR, and Reagan. The criticisms of the court were combined with realigning elections, so the court and the White House and Congress were in step. Have they been out of step for longer than previously? And what would we need to put them back? And what does that say about court curbing? In those four other moments, threats of court curbing, if not bills passed by Congress, were successful. By contrast, in the progressive era, there were threats of court curbing that didn't succeed. So what is the current moment in time, which you focus on in your book, tell us about when we can identify realignments?
So to reinforce, I think a really important point is so many of the things that happen in American politics that have long-term, multi-year consequences, we don't know until well after the consequences happen. So it may be 20 years before you can truly fully appreciate what's happening now, because every decision produces a policy, which produces new politics, which produces new policies, and the cycle kind of goes on. And it reminds me also of something very similar that Steven Skronik, who's one of the leading APD scholars out there, wrote in his book about presidential politics, is that very oftentimes we look back on reconstructive presidencies with this kind of memory hole where we think, oh, how amazingly effective and competent they were, when they also had many deep struggles in trying to form their coalition and to get a grasp on things, right? FDR, for example, had a terrible time trying to figure out what his New Deal coalition was going to look like, particularly 1937 going into 1938, where there was a real struggle of what did it mean to be a New Deal Democrat? What did liberalism mean in terms of the coalition? So every coalition that has these really big, important reconstructive moments tend to be looked back upon with hindsight in a way that the people who were living through those moments may not have also or may not have recalled them as being. And so I think we should always be careful about, and I think that's why I would agree with kind of the stance that Professor Whittington took here, which is you have to be careful in, being too quick to say, this is the reconstructive moment, it's happening, or saying, no, this is absolutely not happening, right? We have to be very cautious because it takes so much time to figure out, which I think is also, by the way, a real plug for American political development as a subfield of political science and as a way to study political history and particularly in law, because time is such an important factor here. What I do think, though, is different perhaps about the moment that we're in, and that's causing some of the the kind of angst that we're seeing in public debate, and some of the positions that are very hostile towards the Supreme Court, is that we are perhaps in a situation where our institutions aren't as majoritarian, at least in the political branches, as they have historically been. Right? In at least from the liberal perspective, if I look back to 2016 in that election, you didn't really hear a lot of talk prior to 2016 about the Electoral College being this deeply anti-democratic institution and feature of American governance. And of course, academics, we talk about things of that nature for a long time, but it probably wasn't on the median voters, tongue at that, until that point in time. And suddenly, with the election of Donald Trump in the Electoral College, but not winning a majority, you saw this kind of outrage about Donald Trump and the ability to secure the White House without a plurality of the popular vote. And at the same time, we have the United States Senate, which is more malapportioned than it ever has been, and it deeply, I think, it reflects in a much more outsized way the interest of rural voters to urban voters and suburban voters, and that has caused a lot of controversy and discussion and debate. And so, when you get to a point where you are nominating and seeking advice and consent for Supreme Court justices, with a president who won in the Electoral College, but never won a majority of the popular vote and never really secured a majority approval in polling. And you had a number of senators approving those confirmations who didn't represent a majority of Americans. You get the sense that people see the Supreme Court as entrenching minoritarian upon minoritarian rule, as opposed to reflecting the kind of dominant coalitions of Americans' political choices over time. And so I think part of the heightened angst amongst liberals is this idea that the court has this minoritarian interest now entrenched in a 6-3 majority, and that somehow is, a really unacceptable degree of being removed from the public's, kind of mainstream public views. And so, you have all that going on. And I think it's only getting amplified by the fact that our politics are becoming increasingly polarized, but especially increasingly polarized on rural and urban suburban lines, which only enhances this kind of problem of the Electoral College seeming to be incredibly problematic from Democratic voters' perspectives, and the Senate being malapportioned as it is. And so we're really tapping into the court as being, is the court as an institution representative of the public that it serves? And you have 50% plus of the country who say no. And you have 50%, more or less, give or take, who say yes. And so that's a really deep division that's going to have to be settled one way or the other, either by just acquiescence and somebody gives up and says, okay, you can reform the court, or okay, there won't be any court reforms and we'll just accept the 6-3 court that we have. I don't know where our politics are going to go, but you have a lot of kind of this background angst feeding into, the court not being viewed as representative. But then the court is kind of leaning into these bombshell issues, which are salient and even more polarizing. And so the Dobbs decision in particular, the backlash that was seen in 2022, into 2023, perhaps into 2024, it's significant. Now, I don't know, and again, this is where time is so important. I don't know what it's going to mean in the long term. I don't know if it's going to affect calls for court reform or electoral outcomes, or if that will feed some kind of structural realignment within voting blocks and voting coalitions that have a long-term impact on the way Americans vote, which is all possible. We'll have to really wait and see. But we're just in this moment, I think, of a lot of agitation, and liberals are agitated, conservatives are agitated. And it's kind of a powder keg that at some point is going to have to be resolved. And it just depends on some of these kind of big, high stakes electoral decisions that the public has to make that will determine the kind of long-term trajectory of where we go on this question.
Keith, what do you think of Anthony's suggestion that one explanation for why the White House, Congress, and the courts are more out of step with each other now is because of these political process changes that lead the court now to represent what he calls a minoritarian conception as opposed to a majoritarian conception? President Reagan, of course, proposed a kind of constitutional revolution, but it wasn't consummated until President Trump was able to appoint justices. President Trump, of course, appointed after losing the popular vote. And is it true that because of changes in American politics, all the institutions of government are less majoritarian than they used to be? And what would that say about the model of constitutional time?
I guess I'm pretty skeptical that that's a good explanation of either where we are or a characterization of how to think about American political institutions at this point in American history, as opposed to other points in American history. It is, I think, certainly the case that we do have a significant rural divide from sort of urban and suburban voters on the other side. And it is true that, given the nature of how our states are currently constructed, that the Senate tends to reflect that divide in particular. But of course, there have been lots of periods in American history where there have been dramatic divides between rural parts of America, agricultural parts of America, and other industrialized parts of America, and more urban parts of America with a very different kind of economic sector and population than other components. Part of what's different about our current circumstances is neither party has built a broad-based coalition that crosses those particular boundaries. So one thing that you saw parties do through most of American history is to work to be able to capture the kinds of institutional structures that we have in design. And so if you were a coalition leader trying to build a national majority coalition in the 19th century or through much of the 20th century, part of your goal is we need to find a set of policy commitments and a party structure that's going to pull in the rural voters as well as the urban voters, so we can win Kansas and New York at the same time, because that's how you build a national coalition in the American system. Part of what's really striking now about both parties is that they've been very content to build these very narrow coalitions that can win very narrow political majorities, but they're very unstable as a consequence. You lose a few voters in a suburb in Milwaukee, and now you've lost your presidency because they are so narrowly constructed with so a narrow set of interests. And that's a choice the parties have made as much as anything. It's not easy to build those coalitions, right? There's real difficulties in how do you construct a successful coalition that reaches across those boundaries. But that's always been true. That's sort of the puzzle of American politics in general. How do you build those coalitions that are going to reach across those kinds of boundaries? And right now, I think political leaders are not only unsuccessful in doing it, but to a weird degree, they're not even trying to do it very much. There's some contingency about that. You can imagine that dramatically changing. So, for example, there was a moment there not very long ago in which it looked like because of Biden's weakness, that maybe the Republicans are really going to run up the score and they would have a massive electoral victory this time around. And suddenly they'd have a really big majority in Congress, as well as actually winning a sizable number of electoral votes and national votes for the presidency. And then their challenge would be, could you hold that together through another election cycle or two, or would you immediately turn that over once you start adopting policy and actually governing under a Trump administration? Suddenly everybody goes rushing back to the Democrats. But those kind of contingencies can make real differences about how coalitions get formed, what kinds of party effects you can put together. I guess I'm also pretty skeptical that some of the court's current difficulties are really a function of these so-called anti-democratic features. So even if you were to grant that the Senate and the White House are less majoritarian than they might once have been, and like I said, I'm skeptical that it's a general claim. But even if you were to grant that, it's not obvious to me that that's actually the source of the concerns about the courts. It seems to me that it's much more true that liberals are just unhappy that they're losing cases that they would like to win. I don't think liberals would be any more happy with Dobbs if they thought that the political coalition that resulted in the Dobbs decision was differently constructed than that. And likewise, I think regardless of how you construct those political coalitions, the kinds of focus on the administrative state and presidential immunity types of structural decisions that the Roberts Court has been making that are quite controversial to some degree are not closely connected in any way, I think, to these larger kinds of democratic concerns. And of course, there's also the longstanding worry that the court's a counter-majoritarian institution more broadly. So even if we take Dobbs as the example of that, Of course, Roe had this weird feature of striking down and making unconstitutional laws that have been adopted by political majorities in every state in the union. And yet Roe swept it all away in a single decision, outraging many conservatives who said, how could the court possibly be so anti-democratic as to wipe away all these laws the Democratic majorities had adopted? And so the relationship between the court and democracy, I think, is complicated in any case, and the connections between how democratic the court is, either in terms of how popular its decisions are, or as a substantive matter, or in terms of the process by which the justices are chosen, I think is complicated relative to confidence and trust in the court, for example. So if you look at current public opinion polls, independents and Republicans seem quite happy with the court, as happy as they've been with the court over time. Republicans much more happy with the court now than they have been in recent years. Democrats, on the other hand, are extremely unhappy with the court right now in ways that are not dissimilar to how Republicans were very unhappy with the court at earlier points. And so some of this, I think, is a familiar situation that the court has been in. Some of it reflects our current polarized environment. Some of it reflects, I think, our general distrust of institutions. The court's overall confidence and popularity is down, but that's also true any other institution you can name in American society, and the presidency and the Congress are even more down in public confidence as political institutions go. So I think we do have a real challenge in this country about how do we rebuild public confidence in public institutions, particularly political institutions. But I'm not convinced this is the right diagnosis as to what's ailing the court in particular, and the kinds of reforms that one might then want to adopt as a consequence of that diagnosis, I think are in fact unlikely to help very much in terms of rebuilding trust and confidence in the courts.
Very interesting. Many thanks for that. Anthony, what do you make of Keith's response that far from being a bug of the counter-majoritarian features of the Electoral College and the Senate, it's the failure of either party to build national coalitions that's resulting from the fact that there's not a new constitutional consensus. And in your book, you do express concern that other modern features, including the fact that justices are living a lot longer, might make it possible for a court to be quite out of step with national consensus for longer than occurred in the past. And what does that reality suggest about that final point Keith made about how we rebuild public confidence in the court? Is both of you express skepticism that the court simply follows public opinion, or that the relationship between politics and the court is simple. But when the court gets really out of step over long decades with supranational consensus, does legitimacy suffer, and how could it be rebuilt?
Yeah, so I think that's a really important point about judicial tenure. So, of course, members of the judiciary live a lot longer than ever. We're a lot healthier than ever, and so you go around and you see judges on appellate courts who were appointed by Ronald Reagan still, or from the first Bush administration. And so I think there's a part of that is affecting the extent to which the courts reflect public views, because there isn't as regular of a turnover because of that that extra healthy life that people are living, and that's great. But for institutions, that are supposed to reflect, or that generally have reflected popular sentiment, maybe that's not serving their interests. The other thing that's historically true is, it was at some point the case where judges were not paid very well. There was no social safety net. There was no social security. And judges, as they were aging, decided to leave the court because they wanted to make some money and save and live well in old age. And so now we have a robust retirement system for federal judges, and we have social security and other forms of a social safety net that don't necessarily encourage judges or justices to leave until they are really ready to leave, or they die on the bench. And by ready to leave, that also this kind of combination of having retirement benefits there, living longer. It also gives an extra ability for judges to strategically retire. And so judges can choose to wait and retire when there's a president in office who reflects their similar ideological commitments, which doesn't necessarily encourage this kind of routine turnover of judges on federal courts. And so, one great example that was in the news today, CNN has reported that Justice Alito was musing the possibility of retirement if President Trump is reelected or elected again in November. But I think, of course, the reverse or the opposite would be true, is that if Kamala Harris is president in 2025, Justice Alito is not going to go anywhere. And so that kind of strategic decision making to kind of keep seats within a presidential party's kind of domain has also somewhat entrenched views, perhaps in a way that I think these calls for court reform are trying to get at, right? Which is just the idea that you should have regular, consistent turnover, and that people shouldn't be able to kind of either plan out with great strategy how they leave, when they leave, and who selects the replacement. Or you don't kind of live in this gerontocracy where you live by the decisions of octogenarian justices. Right now, imagine if Justice Ginsburg, for example, heeded some of the calls to retire during the Obama years. We would be having a very different conversation about the nature and ideological makeup of the Supreme Court. But she chose to stay on the court and, unfortunately passed away in 2020. That created an opportunity for Donald Trump that would not have been there had she chosen to retire earlier. So I think that there's this combination of, institutional changes and statutory benefits that we've created that create a new set of kind of decision making for judges when to leave. The kind of intense polarization of our politics and the polarization of the courts probably has also not encouraged judges to leave unless there is a president of their who's a co-partisan of theirs in the White House. So I think there's a lot of things in the mix here, I don't think there's any really one simple cause and effect relationship that we can identify as to why the courts are acting the way they are or why they have the ideological disposition that they are relative to society. This is going to be a very complex issue that we really need as scholars to untangle, I think, in the years to come. And so there's a lot of work out there to kind of figure this all out. But I think that a lot of the possible sources of angst, possible sources of institutional, the situational relationship between the courts as institutions and the public. I mean, I think we have a lot of different ideas of what might be happening, but it's going to take a lot of time, a lot of thoughtful research, and a lot of good academic work, I think, to flesh this all out.
Thank you so much. We're nearly out of time, but I can't resist a final question because we're learning so much from both of you. Keith, what builds and challenges institutional legitimacy of the courts? Is it broadly following consensuses in public opinion, or is it something more? And what could rebuild institutional confidence in the Supreme Court?
Well, I do think avoiding some of the kinds of personal scandals that we've seen lately surrounding the court would be helpful, at least in building some greater confidence and trust in the court. I don't think that's going to be nearly sufficient, though. I don't think the concerns with the court are strictly about personal behavior of individual justices. I think it's often true that the court builds support and legitimacy in part by taking action. So it is by making decisions, sometimes making bold decisions, that the court demonstrates its value and worth and builds support. Sometimes it needs to make decisions that, in fact, are going to be unpopular. And I don't think the court can simply be trying to follow the public opinion polls or decide that's going to be our path to rebuild confidence. If we just follow the public opinion polls, then everyone's going to be happy with us again. And so maybe we should do that. It's both an abandonment of the function of the court and part of it were to try to do that. I also suspect politically it would not be entirely successful. But so sometimes it's going to it's going to face the fact that it's going to wind up making some unpopular decisions. And sometimes it's going to take a hit as a consequence of making those decisions. But I think it has an obligation and responsibility to try to explain its decisions as best it can, to try to make choices about what decisions it's making. And I think one of the real challenges I worry about, given the polarized nature of the politics surrounding the court now, and given sort of the lessons of history about the court in general, is the possibility that a conservative court, which is what we have now, that's relatively stable, will increasingly find itself making decisions that make perfect sense from the perspective of the justices on the court, but continue to make Democrats and liberals quite unhappy with not a lot of countervailing decisions that are made where liberals see, well, here's what I'm getting out of this court. It's not the case that the court is only making 6-3 decisions or 5-4 decisions or always favoring conservatives. I think that's a mischaracterization of what the current court's doing. But I think it is quite plausible that liberals can wind up looking at the current court and thinking all the big cases come out the other way. And we're not going to benefit a lot from this institution and the continued existence of this. This is what the progressives in the early 20th century did. They looked at the court system in general and said, this is a set of institutions that's very conservative and will always issue conservative decisions in ways that are hostile to the kinds of policies we want to advance. And we'd be better off without an institution like that. And they had very radical proposals on the agenda for how to reform courts or even get rid of courts in order to get them out of the way. And I think it's a very dangerous role politically for courts if they find themselves in a situation where one of the big partisan factions in the United States has come to the conclusion that courts don't have anything to offer to them and they'd be better off radically reforming courts in some way. Courts have been most successful when both parties can look at the courts and say, well, we win some and we lose some, but there's some things that are really beneficial that courts are producing. They do some important work within the constitutional system, and so as a consequence, it's worth swallowing the losses in order to continue to respect judicial independence on the whole.
Courts have been most successful when both parties say we win some, we lose some, but courts do important work in the constitutional system. Very well said. Anthony, last word in this great discussion is to you. What is the main driving force of the court's institutional legitimacy, and what could this court do to restore its legitimacy?
Well, I think the court always has institutional capital that it drains down sometimes and it has to rebuild. And so part of that is reassuring the public that, at least to some measure, that they're getting a fair shake. And so I'll reflect some of the sentiment that I think Professor Whittington articulated. What are the reasons why I think the court used to have a lot of buy-in from liberals, even when it was the Roberts Court, when Justice Kennedy was on it? That there's no denying that the Roberts Court with Justice Kennedy was a conservative court issuing overwhelmingly or by and large conservative decisions. But I think there was a sense by the public, even by liberals, that despite the fact that the tenor of the court was very much right of center, that they got a fair shake, that you never really could quite figure out what Justice Kennedy was doing. Or, before that in the Rehnquist court, you never quite exactly knew what Justice O'Connor was doing and Justice Kennedy. And you never knew exactly, where Justice Souter might land on something. And so I think that there was just this idea for a long time that despite the fact that the court was certainly center right, that people got a fair shake. And so even though I would argue, looking back, the court is still political, it is still producing constitutional law and doctrine that is a byproduct of politics and coalitions and outside influences and all the rest, people still found legitimacy in it because they thought they were being treated fairly. And I think it's that belief that liberals have that this court is not going to ever thoughtfully consider and apply logic to their arguments is kind of creates from the get-go a dynamic where they'll never listen to what the court says unless the majority opinion is written by Jackson, Kagan, or Sotomayor. And so I'm not I'm not sure what the prescription exactly is for that. But I think that to me is really the problem. And we'll have to figure out in the next coming years, and particularly, what in the aftermath of whatever happens in November of 2024 in the presidential election, how the public and how Congress and how the president is going to address that, if at all. And so that to me is the big outstanding question, because I think that's really where this conversation is going to start.
Thank you so much, Keith Whittington and Anthony Michael Kreis, for a superb discussion and casting so much light from American history and political science on American constitutional development. Dear We the People listeners, read their books. Keith Whittington's many books, including Political Foundations of Judicial Supremacy, and Anthony Kreis's new book, Rot and Revival, The History of Constitutional Law in Political Development. Keith, Anthony, thank you so much for joining.
Thanks for having me.
Thank you.
Today's episode was produced by Lana Ulrich, Samson Mastashari, and Bill Pollack. It was engineered by Bill Pollack. Research was provided by Samson Mastashari, Cooper Smith, and Yara DeRese. Please recommend the show to friends, colleagues, or anyone anywhere who is eager for the coruscating light that history can cast on the Constitution. Sign up for the newsletter at constitutioncenter.org/connect. And always remember in your waking and sleeping hours that the National Constitution Center is a private nonprofit. We rely on the generosity, the passion, the engagement of folks who love lifelong learning like you. Your emails are so welcome. If you let me know what We the People means to you and how we can improve. And of course, always your support. So give a donation of any amount at constitutioncenter.org/membership, or go to constitutioncenter.org/donate and donate. That would be just wonderful. Hope everyone's having a great summer. And on behalf of the National Constitution Center, I'm Jeffrey Rosen.